Bonjour, and welcome back to another exciting edition of Coffee with Stephen. So, this week's blog is titled U.S. v. Rahimi, a case trapped in amber. And we'll discuss why it has that little sort of literary alliteration after the name here in a second. But suffice to say, it's a phrase that's used both in the opinion that was authored by the Chief Justice, as well as every concurring opinion and the dissenting opinion in that case. And the phrase itself is interesting and, and will require some level of introspection, I suppose. In any event, for those of you who don't know, there were two cases before the U.S. Supreme Court this term that potentially fell within the realm of the Second Amendment. The first one was Cargill. We got a decision on that a couple of weeks ago, and that dealt with bump stocks. And as it turned out, it had nothing to do with the Second Amendment. Instead, it had to deal with primarily executive regulatory overreach. There was no what we call Bruin analysis to determine whether or not bump stocks fell outside the scope of the Second Amendment. This case, on the other hand, does fall within the Second Amendment, and this case deals with civil restraining orders, essentially asking the question, if someone is under a restraining order, does that potentially strip them of their Second Amendment rights? Well, the court said it does, and they employed the Bruin analysis in order to reach their opinion. Now, that's kind of good, to tell you the truth, because they're remaining consistent to the Bruin analysis. Now, I will tell you that from a personal level, I think that while the court did the analysis correctly, they came to the absolute incorrect answer. And I go over that in somewhat exhaustive details in the blog. Fair warning, this blog entry is much longer than my normal ones. I think this one reaches 7 pages. There is no great forward movement on Second Amendment jurisprudence as a result of this blog. There really isn't a retreat of Second Amendment jurisprudence either. I would say that in the final analysis, our understanding of the Second Amendment remains somewhat static. It does raise some questions as to whether or not restraining orders do in fact strip someone, irrespective of what the Supreme Court says. It does, at least through Justice Gorsuch's concurring opinion, require that there be a certain level of robustness of the tribunal to determine whether or not somebody is a danger to others. But it doesn't really go into detail on that. It also sort of criticizes the methodology that Mr. Rahimi used to challenge this statute, 18 U.S.C. 922. Effectively criticizing the decision to move forward with what we call a facially invalid constitutional challenge versus an as-applied challenge. It's very nuanced, and I'm not going to go into detail on it here. Suffice to say, you can read about it in the blog. I'll call that a teaser. But the real interesting part of this opinion, actually, I'm seeing very little commentators talking about, and that is Justice Kavanaugh's concurring opinion. And in that opinion, he may very well have expanded this concept of the Bruin analysis, where we look to see whether or not a statute is consistent with our nation's history, text, and regulatory traditions outside of simply the Second Amendment, and now has expanded that to all civil rights. I think there is a legitimate argument that that is exactly what happened. In any event, I do encourage you to pour yourself a cup of coffee and read the blog. As always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.